do appreciate it, and we look forward to the wisdom you're going to impart to us today.
Pleasure. Thanks so much, Michelle. Thanks for having me, guys. Guys, this is my first time using the platform, so I've tried to put up the presentation. Can you guys see it? Is it right? Can you see this Schindler's Leapfrog first page?
Yeah, we can see the presentation. All good.
All good. Okay, perfect. Okay, so guys, we are going to discuss trusts this morning. Now, I think it's important to, when you're dealing with trusts, you kind of need to think of them as slightly different from companies and CCs. So, they kind of fall into the same category because they are a separate legal entity. So, they've got a separate legal standing, just like a company and a CC does. But a trust is a far more complicated when you really get into it, and a very different kind of entity to a company and a CC. Now, just to start, guys, with some of the basics. I mean, remember that your companies and your CCs, those are registered with Sept, and that's a public document forum where you can go and you can get, for instance, if you go to Sept, you can get a list to see who are the directors of that company, where's its registered address, that kind of basic information about it, what's its registration number, what's the correct name, that kind of stuff is public information. With a trust, remember that the trust is held by and administered by the master's office. Now, the master's office is unfortunately not as well run, in my opinion, as like SIPSI and the deeds offices, those kinds of things, but that is the entity that looks after trusts, and it's a far more difficult procedure to get information about a trust. So if you've just got a name of a trust, you won't be able to go and pull the file from the trust office. You need the IT number, and that's information that you need to get from the client. But just remember that your housing vehicle for your trust compared to your companies is different. Now, the companies and CCs are SIPSI, and for the trusts, it's at the master's office. But let's just quickly have a very basic look at what are the founding blocks and the essential parts of a trust. So, guys, the most important document with your trust is your trust deed. Okay, the trust deed is the document that sets out what the trust is for, how it's going to be run, what the purpose is, and those kinds of aspects. And in the Trust Act, there isn't really much regulation as to what needs to be in there. If you've got for companies, for instance, because remember, you can't form new close corporations, you can't form new CCs, but you can form new companies. And how you're going to form that is very highly regulated in the Companies Act. For the Trust Act, it doesn't really go into much regulation about what needs to be in your trust deed. So it gives you a lot more freedom as to how you want to set up your trust. For whatever you want to have it as, how many beneficiaries, how many trustees, what the purpose is, all of those kinds of things, how it's going to be administered, that kind of thing. There's a lot more freedom as to how you can set up a trust. So that trust deed is your founding document for the trust. Then you must have at least one trustee and one independent trustee. Now, guys, most trusts will have 3 trustees. Okay, most of them will have 2, trustees who will be part of the family or whatever it is, and then you'll have an independent trustee who will help with generally the administration of it. But generally speaking, you want to have 3 because you've got your 2, let's call them family member trustees, and then you've got your independent trustee. You want to have 2 just in case one of the trustees were to pass away. You've still got the control of the trust basically with somebody within the family, and then you can appoint somebody new from there. Of course, there must be the one beneficiary as well. So remember, guys, the whole purpose of the trust is I have the trust to own whatever it's going to own. It's going to be administered and run by the trustees for the benefit of the beneficiaries. That's the whole purpose of a trust, is that it is looking after that beneficiary. We all want to be a little trust fund baby. I mean, some of us missed out on that lotto, unfortunately, in life. I'm still waiting for my trust fund to come in. But we all want to be a little trust fund baby. We don't all get the opportunity, but essentially the trust fund babies, they are the beneficiary of the trust. So they've got mom or dad or whoever it is who are the trustees of the trust administering it, making sure that whatever it is, the wealth creation of that trust is doing the best it can for those beneficiaries. And guys, just to clarify, you can be a trustee and a beneficiary of a trust as well. Okay, so you can be both the beneficiary and the trustee. Guys, the individuals, there's the people that you're referred to in a trust is there's a planner. The planner is the person who initiates or starts it. The founder is the person who establishes the trust at the master's office. Then you've got the trustees, which we've spoken about, the beneficiaries, which we've spoken about as well, and then the master of the High Court. Okay, so the master of the High Court, of course, is the person who oversees the trust, is supposed to keep the files and filing of the trust and keep everything organized. So for every trust, guys, there should be a file at the master's office that has the latest trust deed, the latest letters of authority, and any other information on the trust that needs to be filed with them. So, guys, when it comes to the establishment of trust, there's two ways that it can be done, and you're probably familiar with them already. The first one is a testamentary trust. That is a trust that is formed in terms of a will. So, of course, the situation with that is, generally speaking, you'll see in people's wills, especially if they're married and they have children, they say that if we were to, if myself and my spouse were both to die at the same time or simultaneously or within 2 weeks from each other or something like that, the executors of our estates are instructed to form a testamentary trust, and they will set out in that will, okay, if the testamentary trust is set up, who's going to become the trustees of that trust, and the beneficiaries, of course, normally would be the children, but it can be anybody. And the trustees of that trust must administer whatever the assets are that was in their estate and make sure that it looks after the children going forward. So generally speaking, that's, if the children are going to be under 18, as soon as children are past 18 or past 21, or, you can set whatever age you want it to be, that the assets will actually be transferred to the children. If you don't trust your children very much, you can make it 35 if you wanted to, but generally speaking, it can be anything from 18. The trust will be set up, and then when the children get to that age, the trustees will then see to it that the assets are transferred to the beneficiaries. So that would be your testamentary trust. And then, of course, the other trust is called an inter vivos trust, and that is just a trust that is formed by agreement. So that's just a decision that you take right now to form a trust for whatever the purpose is that you are going to form that trust for. Okay. So, guys, like I said, there's the Trust Property Control Act. And you can see in the last sentence there, it says that the Act does not regulate the content of the trust deed, but rather deals with registration and various administrative issues. So what that means is that when you're forming a trust, really it can be for whatever purpose you want. You can run it basically however you'd like. The Trust Property Control Act just sets up how you set up these trusts. But I just want you to have a look here. The authorization, okay, so in terms of the act of a trustee of a trust, they may only act in such capacity if they are authorized in writing by the master. Okay, and that is, guys, especially when you're working as an estate agent, that is one of the most important things to remember, is that anybody working on behalf of a trust, they can only do so if they have the authority of the master of the High Court to do that. And what is that authority? That is that letter that we should all know by now, called the letter of authority. The letter of authority from the master's office is that document that sets out exactly who the trustees are. And guys, when you are dealing with a trust, the most important, I know FICA is an absolute pain, but when it comes to trusts, you have to get that important piece of FICA right early on. Because if that person is not a trustee on the latest letter of authority for whatever reason, that is a big problem. You either can't be dealing with that person at all, or they need to go and they need to get that letter of authority updated at the master's office. Now, that process, if you've got everybody around to sign the documentation that you need to get an updated letter of authority, shouldn't take you more than 3 to 4 weeks to get it done. So it's something that can be resolved relatively early. But when you are dealing with the trust, and this is whether you are dealing with a seller or a purchaser, guys, you must make sure that you get that letter of authority as soon as possible. Anybody on behalf of the trust should know exactly how important that document is. It's only the people whose names you see on it that you can deal with regards to that trust. then guys, with regards to the Alienation of Land Act, so any sale of property needs to be done in writing by the person authorized to do so. Okay, and that's why it's so crucial that you get your letter of authority, so that number one, that that person has the authority. And there's two really important legal aspects that flow from this. So when you're dealing with a company, you can have somebody come to you now who can sign an agreement on behalf of a company to be formed. So if I'm in the process of forming a company, I can come and sign as a buyer with you now. And once the company is formed, I can then sign the resolutions and we can just proceed with the transaction as is. With a trust, remember that it doesn't work like that. It's not legally permissible for you to sign an agreement of sale as a buyer on behalf of a trust to be formed. Okay, there's no legal basis for it. That agreement is not going to be worth the paper that it's written on. If somebody wants to purchase something with regards to a trust, and I'm not saying, guys, at that point that you scare them away and you don't take the offer. You just need to realize that somebody who's signing on behalf of a trust to be formed, if they're going to put an offer for you now, the discussion you need to have with your principal and with the owner of the property is that until that trust is formed and the agreement is re-signed, you don't actually have any binding agreement with anybody. So you must just realize that if you're in that kind of a situation where somebody's in the process of forming a trust, nothing is actually going to be binding on anybody until the trust is formed. Okay, after the trust is formed, then you can sign the agreement correctly and it can be binding from that point on. But anything prior to that, it's not going to be binding. And the other totally different aspect with a trust compared to companies and CCs is that I can sign an agreement right now on behalf of a company or a CC with no resolution in place, and I can sign the resolution later. And once the resolution is signed later, the agreement is what we call ratified, and now the agreement is binding and can move forward. With a trust, in terms of the Trust Property Control Act, you cannot do a resolution later condoning it. And guys, that is without a doubt the most common mistake that is made in the real estate field, is people taking agreements of sale or offers to purchase from people on behalf of a trust, and there is no resolution in place. That agreement is not going to be binding. Even if you do get the resolution done later, you're going to need to redo the agreement at that point. So it's absolutely critical, guys, when you're dealing with the trust, you get a resolution from the trustees early in the process. And you don't have to, you can get the resolution done by a selling trust prior to you actually having an offer from a buyer. You can just say that, they've mandated Leapfrog to sell the property, and that any purchase price, above or any purchase price above whatever, or you can leave the purchase price blank as well. But it needs to set out that they've instructed you to mandated you to sell the property, and that XYZ person of the trust is authorized to sign the offer to purchase on behalf of the trust. And that resolution has to be dated before the OTP, or at the very least on the same day that the OTP is entered into. And guys, that is by far and above the most common mistake that's made when dealing with trusts. And what you need to remember as well, guys, is we have people come to our offices and say, look, I've entered into this agreement. I want to pull out, whether it's the seller or the purchaser. They'll come to our litigation department and they'll say, look, I need to get out of this transaction for whatever reason. And if one of the parties is a trust, just remember that it's as simple as the litigation department will just be able to draft a letter to say, please provide us a copy of the resolution that predates the agreement of sale. And if such resolution does not exist, this transaction was void ab initio. It was never binding from the beginning, and we'd like our client's deposit back, or whatever it is. And so just remember, guys, that is like one of the easiest ways for somebody to get out of a transaction, is when you're dealing with a trust, if that resolution hasn't been done timeously. So the vesting of immovable property into beneficiaries' names. So, of course, there's often, especially with the testamentary trusts, where somebody has passed away and they've created a trust for their children. Of course, the intention there often is that the assets, whatever the husband and wife who've passed away, whatever they owned, they want those assets eventually to be vested into the beneficiaries' names as the children. Just one of the tricks with that is that transfer duty on that transfer, because let's say it's a 5 million rand property and it's now going to be transferred to one of the children now that they are of age. As long as as long as the beneficiary is related to the founder of the trust, it's going to be free of transfer duty. Okay, but that is generally speaking the only instance. So if you've formed a trust yourself during your lifetime and now you want to transfer stuff to your children later out of when you want to vest some immovable property to the children, if you formed it yourself during your lifetime, that transfer to the children is not going to be exempt from transfer duty. It's only really in those testamentary trust situations where somebody has passed on and in their will they've created the trust. That's when it's going to be exempt from transfer duty. But there's, guys, it can be quite complicated. There are obviously attorneys who basically specialize just in working in trusts, and there's exceptions to every rule. But that's really the rule of thumb, is that the only time that a transfer out of a trust is going to be exempt of transfer duty when it's went to the children from a testamentary trust formed by their parents when they passed away. So yeah, guys, one of the things that I mentioned earlier, access to trust information, it's not the same as companies and CCs. It's far more difficult to get access to documents about trusts, and that's why really you actually rely a lot more on your clients to give it to you, because you don't really have a portal to that information at the master's office. And like I said, if you've got the name of the trust, that only helps so far. And if you do a search on a trust, for instance, on Windeed or Lightstone or anything like that, it's not going to give you the trust registration number. And that trust registration number is what you need to go to the master's office to find the file for it. So just remember that when you're dealing with the trust, you really are relying on the client for the information. And that's really why the most important thing early on is to get that letter of authority. Stanley's asked, is transfer duty payable when transferring a property from a family trust? So Stanley, it would normally be payable. If you've got a family trust, remember, and when you say family trust, I'm presuming it's a family trust that was not created in terms of a will. So the trust was not created because somebody passed away and in their will they said, if I pass away, I want these assets to go into a trust. If you're talking about a family trust where a family gets together and they decide, okay, guys, we've got all this asset wealth, it's best for tax purposes that we put it into a trust. Okay. Now, if at any point after that, they're going to be transferring property out of the trust to any of the beneficiaries, there will be transfer duty payable there. And of course, if somebody is buying property from a trust, if I'm not connected to a trust, but I'm buying property from it, normal transfer duty applies. So generally speaking, there's only one instance where there's no transfer duty payable, and that is where it's being transferred to a child out of the testamentary trust. Okay. So I think Stanley's typing again. I don't know if there's another question, but okay, I'll check now. Guys, with regards to trusts and capital gains tax, just remember that there's a reason why people are probably forming less trusts today than they have in the past. And that is one of the main reasons for that, is that right now you pay the absolute highest rate of capital gains tax when you are making a capital gain in a trust. Okay, so it's now at 36% generally, guys. That is what the percentages of tax that you're going to pay. And that is, if you're selling out of your own personal name, just for instance, remember that you get the 2 million rand first capital gain as your tax rebate. So you pay zero tax on that. And then after that, most likely the maximum tax that you're going to be paying is about between 19 and 21% out of your own personal name on capital gains tax. So it's the first 2 million rand free on your primary residence, and then about 19 to 20% after that. If you are selling a property out of a trust, and guys, a lot of people bought property into trusts thinking that it was going to be beneficial for them in a capital gains tax sense, 20 years ago or so, or so now. Remember that when property is owned in trust, number one, you do not get that 2 million rand rebate at all. You only get the 2 million rand rebate for your primary residence if you own something in your personal name. anything in a company, CC or trust, you do not get that 2 million rand rebate. So now let's just say you sold the property with a 2 million rand capital gain now, you would pay 36% capital gains tax on that. That is 720,000 rand tax payable on your 2 million rand gain. And if you compare that to if you had it in your own personal name, if you'd made it that 2 million rand gain, you would pay 0 capital gains tax. So you can see that they have really ramped up the tax on capital gains on trusts, and that was to try and prevent people from trying to shield assets in trust in this way. The other aspect with regards to it, guys, is that the effective tax rate for a trust has increased to 45%. So they really are putting the squeeze on trusts in a tax way. I mean, it's not to say that there aren't circumstances where trusts are not still beneficial. The main, and we're going to get to it in a bit, but the main benefit that you're going to get now from a trust is if you hold a lot of wealth, your estate is worth more than 3.5 million, for instance, and you want to find some better way to avoid paying the 20% estate duty to SARS upon your death. That is probably the only real way that it's got a tax benefit for you at the moment, because as you can see, with the increase of CGT to you paying 36% on your capital gain from Rand 1, because there's no rebate whatsoever, and the increase on the effective trust rate for trusts to 45% on income, I mean, you can see they've really started to make it very, very unpalatable to a lot of people. So guys, I mean, that makes trusts, as we said, as a direct ownership vehicle, very unattractive. So many investors rather opt to purchase property into a company and have the trust own the shares in that company, because now at least you don't have that direct ownership. Because as you can see, with the direct ownership, you really are getting hammered in taxes there at the moment. So guys, interest-free loans with trusts. I mean, if you think about it, if I own a trust now, if I form a trust now, of course, when I form it owns nothing at the time. And now, if I have all these assets, I need to now transfer them into the trust for whatever the purpose of that trust is going to be. And so, of course, what people were doing previously is they would have, let's say, a 5 million rand house in their own personal name, and they would transfer it into the trust. Now, generally speaking, there wouldn't be a flow of money in that instance, because your trust is just formed. It has no assets, it has no income, it has no cash. How is it giving you a quid pro quo for that transfer of that property into the trust? Now, there are a couple of ways that this could be done. People would do donations. Okay, remember, guys, if I'm going to donate something of value from a trust or to anybody, I'm liable for 20% donations tax as the person making the donation. So if I am donating a 5 million rand property to a trust, I am now, what's that? That's a 1 million rand donations tax that I must pay to SARS for making that donation. Okay, now that's a very unappealing prospect for most people. So what they were doing is they would generally be doing loans. So I would transfer the property to the trust, and I would get a written loan between myself and the trust that the trust owes me 5 million rand. But SARS is well aware that the intention of people, generally speaking, was not that the trust was going to repay me that 5 million rand. So again, they could view that as a donation, or if they saw that it was an interest rate that was too low, they would start to tax people on the difference of the interest rate between what they think is normal at the 7.75 and whatever interest rate you had set. Now, generally speaking, people would set 0 interest rates at these things. So you can see that over time, what SARS has been doing is they've been trying to fill in the gaps and try to see what tax they can get from people in how they've been using these trusts. Because you can imagine that, there are obviously families out there with massive wealth. What if you've transferred 100 million rands worth of assets into a trust? And, there's potentially donations tax there, 20%, so that's 20 million rand. Or if there's no interest on these loans that have been created where, generally speaking, the trust is not going to be repaying these loans back, whatever the difference on the interest is there, they're going to start taxing them on that on quite a strict basis as well. So, guys, I mean, it gets extremely complicated. I mean, we don't, to be honest, we don't work in this interest-free loan section at all. And of course, you'll have accountants who will be very sharp guys who will structure it as best as possible. But, you guys aren't really expected to give advice on this kind of thing. And in fact, you should probably avoid giving people any kind of tax advice at all, because this is the kind of stuff that real specialists will deal with dealing with it. But I think it's just good just to have a background knowledge and just to understand maybe as well why we are seeing less and less trusts being formed at the moment. And guys, just on that capital gains tax thing with the trust, people often think, okay, I'm going to buy a property into a trust because I'm going to own it for 40 years, and then I want it to be administered and be used to look after my children going forward. But generally speaking, like the stats show that whether you're buying in a company, trust, CC, your own personal name, all properties get sold on average every 7 years or so. So people go into these things with the best of intentions, but they generally, life changes, your needs change, whatever it is. And if you've got a property in that trust, you're going to be taxed at the absolute maximum basis on a capital gains tax basis. And as you can see, SARS is tightening the loop on how you get that trust asset into the trust and trying to make sure that they're able to tax you on that process as well. Okay, I think we'll skip over that one. Okay, so we've done a list of the advantages of using a trust, but I think, guys, the most important one, by a long way, the reason why people put property into trust is estate planning and avoidance of estate duty. So I know we've got a bunch of different benefits there, but this is really the most important one, especially for the mega wealthy, because you see, when an individual dies, estate duty is levied at the rate of 20% of the value of the estate over 3.5 million rand. Okay, 20% of the value. So if you have a massively wealthy individual who is worth 100 million rand, now there's going to be 20% of over 3.5 million they're going to be taxed on it, and that gets paid to the state. That's obviously very unpalatable to very wealthy people. So this is really the part where a trust does have a real benefit. As you transfer those assets into the trust, you keep your value of your estate under 3.5 million, and then you avoid paying that massive estate duty of 20% over 3.5 million. And that's really, for me, I think that is by far and away the biggest benefit that a trust can provide to someone. I mean, obviously not everybody's in that position where they pass away, they're going to have an estate worth over 3.5 million rand. But that is why, people are often trying to offload assets prior to them passing away. But if you can get those assets into a family trust, you're going to be saving yourself a massive amount of tax there, even if you do have to pay some tax in transferring the property into the estate. But really, in my opinion, that is by far and away the most valuable use of a trust at the moment. The days of forming a trust as a property investment tool, I mean, in my opinion, guys, when somebody's coming to you and asking you, look, I want to buy a property for investment purposes, what is best? Should I be putting it in a trust, a company, a CC, my own personal name? It's a very difficult question to answer. But if you're going to be putting it into a trust, you better have a very, very good reason for why you are doing that. And it must be very, very clearly thought out, because a trust is going to suffer the biggest tax when you eventually sell that property out of the trust, and you will sell the property out of the trust one day. One day it is going to be sold out of there, and you will at that point pay the highest capital gains tax rate. So for somebody to be forming a trust nowadays, in my opinion, for a property investment vehicle is generally not the best idea. You're going to be paying, remember, the lowest capital gains tax out of your own personal name, even if it's not a primary residence, even if you're not getting that 2 million rand rebate, even if you're buying a 1-bedroom apartment and you're renting it out, so there's no primary 2 million rand rebate there, you're still paying the lowest amount of capital gains tax when you sell out of your personal name. Next up after that is the companies and the CCs, and then at the top of the pile is the trusts with regards to the CGT. So generally speaking, you can, of course, there's no there can be situations where a trust is the way to go, but I think those situations are becoming fewer and fewer as SARS tries to tax trusts more and more. And generally speaking, it's not going to be the best vehicle to use. Now, of course, you must be, excuse me, guys. You must be careful of giving that kind of advice to people, because that's the kind of stuff that they should get from their own financial planner or a chartered accountant or an attorney or something like that. But just generally speaking, you've got to have a very, very good reason to do it. But yeah, just on the advantages of trusts, I mean, there's a protection of trust assets, of course, because you don't have direct ownership, protection of beneficiaries. So, I mean, just for instance, when I started working at Schindlers, there was an estate that we administered as trustees, and what had happened was the father of this woman had passed away. She was in her 40s, but she was very mentally unwell, and she had an addiction problem. And he was a very, very wealthy individual, and so he created a trust that would hold all of his assets, and we would administer it and pay her funds out of the trust, but she would have no access to it. So it was just a vehicle that he could set up just to make sure that she would be looked after indefinitely going forward, so that she was never actually going to get full access to those funds, but there was somebody who was going to be responsible looking after that money and making sure that she was looked after going forward. So, that's another potential good use of a trust, is if you're trying to look after a loved one that can't quite look after themselves. So yeah, trusts are relatively easy to form. I mean, if you've got all your documents signed, you can submit to the master's office. It probably costs you about 7,000 Rand or so, with an attorney helping you set up your trust deed, and you'll have your trust set up within the next 3 to 4 weeks. Like we touched on earlier, there is a lack of trust regulation. So you can really set it up however flexibly you'd like to. And perpetual succession, I mean, they're uncommon, but you do have long-standing trusts that just keep on rolling from generation to generation. And like we discussed earlier, that is a way of making sure that you're paying as little estate duty as possible to the estate, to the state, rather. Okay, so of course, I mean, the capital gains advantage to a trust is that if a trustee or a beneficiary passes away, there's no capital gains tax trigger. Generally speaking, if I pass away and I own property, that is going to be, I own it in my personal name, that is going to be a capital gains tax payment trigger. If somebody involved in the trust somehow passes away, it's not something that's going to trigger any capital gains tax being paid. Then, guys, on the disadvantages of trusts. So look, we've gone into the tax side of it, but really the trust is probably the most complicated to run of all of the entities, because it's a bit more free in terms of the regulation. There are more duties on the trustees to make sure that they have to remember that their fiduciary duty is they must work in the best interest of the beneficiary. And of course, you can imagine there are plenty of instances where trustees have not, they've got the control over all of the money and the assets and whatever. There have been plenty of instances where they've been negligent or they've been fraudulent, where trustees have abused their position in the trust, not worked for the best interest of the beneficiaries, and that's led to various issues going forward. But it is quite an onerous position. If somebody asks you to be a trustee on their trust, you must consider it very carefully, because there's a lot of administration with checking the finances. You can, if you don't act perfectly, it's very easy for someone to start pointing fingers at you. And you can imagine in family trusts, there are massive fights that can sometimes spark up, and massive litigation that's been taken between trustees, between beneficiaries, and between both of them as well. So just remember that it is an onerous task. And if you don't know the first thing about trusts, it's probably something to avoid if you can. So another thing is you can be liable for the actions of your co-trustees. So, you've got yourself, another person, and an independent trustee. If the other person is some kind of a loose cannon or steals from the trust or does something fraudulent on behalf of the trust, you as the co-trustee, you can be held liable for those things as well, because you are supposed to be working on these things together. That's why I'm saying that you must take the decision to be a trustee in somebody's trust very, very seriously. And if you're going to do it, you actually need to really put in some effort with it, unfortunately. Okay, I don't think that needs to be touched on. Okay, and then guys, aside from that, of course, with trusts, you've got to have them audited every year. So you've got those additional costs. You generally need expert advice in setting them up and in running them. So there's going to be additional costs in that. And then, of course, we've touched on the tax rates as well. And guys, I think, I've heard Marius say this a million times, but when people talk to him about forming a trust, you have to make sure that you have the appetite for forming a trust. It is not a simple process. It is something that you really need to think very hard about. You need to think about how much effort you're going to be putting into dealing with this trust going forward, because you can't just leave it to the independent trustee to deal with these things. You have to have meetings. You have to keep minutes from it. You have to have resolutions in it. And you need to make sure that you are conducting the trust properly in terms of the act. And it's quite an onerous thing. So it's definitely not something to take lightly. I know people have, it's kind of got like a, having a trust has got like a grand feeling to it. You've got a family trust, or you've got this trust, it's kind of got a level of esteem about it in trusts that compared to companies and CCs. But at the end of the day, they are just tightening the noose with regards to taxes on it. It takes a lot of effort to run the trust. And, there's potential liability for you as well, because you can have a co-trustee do something that can then lead to you being liable for it as well. So generally speaking, if somebody's going to be starting a new trust now or buying property into a trust, they need to have a very good reason for it to actually be worth it. Oh my gosh, Liron is going to be testing my legal knowledge here. He says, if the beneficiary of the trust is declared a prodigal by the Master of the High Court, will the person in charge of administering the estate be required to control how much the beneficiary can access at once, or how the beneficiary can use the assets, or would the planner have to stipulate how to control the prodigal's access to the assets? So, Laurent, it should be set out in the founding document of the trustee, of the trust, rather. It should be set out there as to how the things are going to be administered. If somebody does, for whatever reason, concern the trustees to the point where they think it would be negligent or irresponsible of them, or they wouldn't be living up to the wishes of the deceased to allow for the assets to be distributed to them, for whatever reason, if they thought this person was, a drug addict, or didn't have the mental faculties, or was mentally disturbed in some way, they would need to make an application to the court. And essentially it's to the court, but it's to the master's office. They would be going to the master's office to say, look, because remember, guys, at the end of the day, the function of the master's office is to look after the people who can't look after themselves. That's why the master's office is the person who looks after minors. If a minor is orphaned, the master's office is the one who looks after that person. If somebody is, if somebody has some kind of a mental deficiency and they need a guardianship placed over them, for instance, the master's office is the one who grants the guardianship over it. It's always the master's office that is supposed to be looking after those that cannot look after themselves. So if you, as the trustee, thought that a beneficiary should not get that stuff for whatever reason, you would make an application to court, and you would have to convince the court that it would have been the intention of the person who had passed away, and that it's in the best interests of this person, of this beneficiary, that the assets be withheld or let go in a more gradual process. Okay. So guys, I think that's pretty much it on trusts. If anybody has any questions, you're welcome to fire away. Pleasure, Laurent.